Thank you very much, and my warm regards to the chair of this session. Also my regards to the fellow panelists. When the organizers spoke to me about my interest in the themes, the one that stuck with me the moment I read the detailed note that was prepared and shared with me was this session on indigenization and decolonization of legal education in India. And right from the very first session that we had, the inaugural session, where stalwarts spoke, especially Professor Mitra spoke about the status of legal education in this country. Of so many things that he spoke, one observation that he made, rather one comment that he made that also stayed with me all day long, and I've been thinking about it. The comment that he made was that in India, law should be taught by English professors. Professors who have been trained in English tradition. Professors who imbibe English values, and law in Indian universities ideally should be taught by English professors. I'll come to that later. But let's see how it all started. Legal education that we see today had its origin at around the same time when the process of codification began. Legal practice started even earlier. In fact, the first act that was enacted before the British Crown took over the administration, and we formally became a British colony. That was way back in 1834, which abolished the discriminatory practice that only a certain person coming from a certain religious belief would be a competent pleader to plead cases in, especially in Mufassil courts and all. Legal education, and this is something which Dr. Manvendra also talked about, that how legal education was not even considered to be part of the mainstream education for several years or even for several decades. So when we had laws that were given by those who were trained in English traditions and were conversant with English values only, it was no surprise that we got what we today have. But then, what are those Indian values that we want in our laws? I was with very keen interest, I was listening to a few other speakers who were talking about infusing Indian values and also including a component on Indian jurisprudence. Indian jurisprudence in the law schools should be taught. There can't be any disagreement on that. But teaching Indian jurisprudence and having those colonial laws with colonial values is something which I don't quite understand. Jurisprudence, as it is called, lawyers' extraversion, would remain even a greater extraversion if it is divorced from laws and is unable to shape the laws that we have today. I understand that I have to finish whatever thoughts I have within 20 odd minutes, so I won't be going off the track, of course, which I often do. I won't be, ma'am, this time. So I was reading this this paper. I basically am a student of criminal law, so criminal law and different hues, varieties and facets of criminal law would always be part of whatever I speak about, examples and all. I was reading this 2014 paper, which is very basic and is available for free download at the University of Buffalo School of Law's website by one of the very prominent contemporary scholars of comparative criminal law, Louis Chisa. The paper is very basic, in fact, and he talks about the genesis, development, the route that comparative criminal law scholarship should take, and also talks about the challenges in comparative criminal law scholarship. The first challenge that he talks about is the language barrier. And allow me to quote straight from that paper, the most obvious challenge to engaging in comparative criminal law analysis is overcoming language barrier. While this is a problem that plagues comparative law in general, it is particularly acute in the case of comparative criminal law. The dearth of English translations of foreign criminal law cases, statutes and scholarly writings is remarkable, especially when German, Italian and Spanish, Indian is missing of course. Criminal theory have achieved a very high level of sophistication. Similarly, the lack of translations of textbooks, articles, statutory materials and case law originally published in English hinders the propagation of Anglo-American criminal theory to jurisdictions steeped in the European continental legal tradition. But then, even if we have these, we have to first identify that what values are in fact truly Indian values. In the same paper, though in a different context, he gives an example, and many colleagues would be identifying with that example. He gives this example of an initial elementary criminal law class in any common law jurisdiction when we talk about liability, criminal liability especially, and conditions of criminal liability. So one of the conditions is that the person who has to be declared criminally liable must be attributed with the conduct. And then comes that whether omissions are included in positive conducts and all. So in India, what we teach and what we have been teaching since at least 160 years or so is that you are not liable for omissions unless and until there is a legal obligation to act in a certain manner. So he in fact gives this example of a question that would a person who fails to rescue a stranger who is in distress be criminally liable in our legal tradition? And the answer that every student would be giving is no. Is that an Indian value, that you don't help someone in distress? Have we tried to infuse that Indian value in the so-called colonial laws that we have had, and for centuries to come we are going to have? I completely agree with what Professor A.P. Singh said, that it would take centuries before we in fact attain whatever objectives decolonization and indigenization would have. But few would know that in continental law countries there is this Good Samaritan law. Good Samaritan law would make you criminally liable if you are capable, and if it is doable and you fail to rescue someone, even a stranger who is in distress. So you would find that not only in the continental European countries, but also in those countries that were colonized by the continental European parts like Spain and Germany and France, especially in the Latin American countries and a few African countries, you would find that their laws would also provide for criminal liability and would have some element of good Samaritan law. Who is stopping us? That's a universal value, a lot of values. Who can say that those values that we have in the Universal Declaration of Human Rights are not Indian values? Of course, we have. Our value system tells us that we should not discriminate. Women should be honored. These are Indian values, of course. These are Indian values. So only romanticizing Indian values and only claiming that this is Western and this is Indian, we are following certain Western traditions and Indian traditions must be followed, is something which I find a little problematic. Though this is not a rebuttal, but as a student of criminal law, I am certainly interested in the ancient criminal jurisprudence as well. The former speaker very elaborately dealt with the criminal law, especially I was especially interested in that part, sir. With all due respect to you, I would tell you that the criminal law that we have in our great ancient text is a primitive criminal law. The entire focus has been on punishment. It has been on punishment. Certainly, what we call expiation has been part of Indian tradition, but entire focus has been on punishment and how punishment should be awarded by the king so that he maintains his dignity and position and power and remains popular is all that we have. I did not find in any Indian text on criminal law any definition of any offense. That's a very important aspect. There are a lot of discussions on what should happen to those who commit murder, but what constitutes murder is missing. Lot of discussions on what would happen and what punishment should be given to someone who commits theft, but what constitutes theft is missing. And even after so many years, even after those claims that we have been hearing that these three, I'm skipping a lot of slides, in fact, so that I could sum it up. Lot of claims have been made, and we are awaiting any day those Bharatiya laws would be enforced, Bharatiya Nyaya Sanghita, Bharatiya Nagarik Suraksha Sanghita, and Bharatiya Sakshi Adhiniyam. There is nothing Bharatiya, I'm sorry to say. If we are talking about those values which are enshrined in the ancient Indian text, I am sorry to say that there is nothing in the Bharatiya Nyaya Sanghita, there is nothing in the Bharatiya Sakshi Adhiniyam that is going to be enforced, which we may call an Indian value, based on Indian value system. Now there was nothing stopping the parliament and those who claim that this is an effort to decolonize criminal law. Haven't we been told that we are replacing Indian Penal Code with BNS because we want to decolonize? We want to replace CRPC because we want to decolonize. We want to replace Bharatiya Sakshi Adhiniyam, Indian Evidence Act, because we want to decolonize. See what they found about us When Stephen drafted the Indian Evidence Act, he said that Indians would lie, even those situations where ordinarily people don't lie. Indian Supreme Court has said a number of times that those principles of English evidence law would not be applicable in Indian circumstances. So have we identified those values that we call Indian values, and have we ever made any serious effort of infusing those Indian values into our laws, which we can make and unmake at our sweet will? Now, coming to the other aspect of decolonization, and a lot of deliberations. In every session there was one or other aspect touched as far as languages are concerned. Languages. See the irony. We don't even have an official Hindi translation of the Bharatiya Nyaya Sanghita. I am reminded of a legal historian, C.P. Albert. C.P. Albert writes, and I quote, that when the Indian Penal Code was to be enforced, its enforcement was deferred by almost 2 years. It was on a statute book in 1860, and then it took another 2 years. What happened during those 2 years? C.P. Albert writes, and has been quoted in almost every book on Indian legal history, that penal code was translated in every Indian language. And there was a saying in Bengal that every herd boy would carry a red umbrella in one hand and a copy of a penal code in another. So, national education policy, which has a paragraph which has been repeated many times in almost every session, I won't be repeating. It talks about bilingual or multilingual legal education. Bilingual, multilingual legal education and legal education in a vernacular, these are two entirely different things altogether. I would be humbly submitting. Now, we have this vision of producing lawyers who are competing with their global counterparts in the niche areas. Certainly, we need to rethink this obsession with the teaching these laws in the Indian languages. I came across this again, several news which appeared at different times. One that I got was of 2017. Give verdict copy in the vernacular. Why? Because the verdict copy which is given in English cannot be read by many litigants, of course. Majority of the litigants would not be reading it. And this is what the then President Shri Ramnath Kovind ji had had said. And as we know that Supreme Court has undertaken a translation project, and the latest that I read in Hindu was that SC's translation project raised ahead in 2023, but is finding a lot of stumbling blocks. One of the stumbling blocks are again an obsession with standardized language. This standardization has done a lot of harm, I would again say. There are a lot of words in our daily parlance that we use, which would not be acceptable if we are unduly insisting on a standardized Hindi, or for that matter, a standardized Tamil. Now, if we have to sort of make this vernacular as a medium of instruction, first we need to see that whether the standardized Hindi is doing any good or is unduly burdening. Lot of words come to my mind at this moment, which even someone who is very well versed with Hindi would find very difficult to understand what does it mean. Negotiable means par kram mein. I never heard that word being used by anyone in his daily parlance. In daily parlance, par kram is something which is unheard of. But that is the standard Hindi that we have for translating par kram, for translating negotiable into Hindi, and instrument is likhat. So I have a lot of examples. Certainly time doesn't permit to cite those examples. So what I find is that the way forward is sort of in dark, but a beginning has to be made, no doubt about it, by identifying those values in the existing laws and the jurisprudence, which we may also call Indian values. Tracing exclusive Indian values and then looking back may not be very productive when we talk about globalization and producing globally competent lawyers and academicians. Thank you very much for your patient listening. Thank you.